I beg your lordship's indulgence. On matter for premiering, my lord, on matter for premiering on 1/4/2025, my lord.
Matter of?
My lord, it pertains to appointment of Dalayats, my lord. The learned single judge has set aside all the appointments and has directed the government, my lord, to redo the list, my lord. My lord, I will be out of the list, my lord. I am in the threat of termination, my lord. Similar matter, my lord, it is coming up on the 1st, my lord. I please your lordship may take it up on Tuesday, my lord. I will be relieved, my lord. My lord, I am working since 3 years, my lord. I will be relieved of my services. Similar matter, my lord, in fact, your lordship was entertained and passed an interim order, my lord. Similar matter will be posted on 1/4, my lord. Please, my lord.
First. Yes, madam.
Your lordship's kind leave. If I may be permitted to make a mention of serial number 92, my lord. Senior is held up in an outstation matter, is unable to be present before your lordships, hence seeking for a week's time, my lord. It may be listed anytime next
June.
week.
5th of June.
Please, my lord.
5th of June.
My lords, greatly obliged.
As send out to 5th of June.
My lord's
As
contempt petition.
request.
Serial number 102, your lordship heard it yesterday. I asked for one more day's time because some personal inconvenience today. It may be taken up any date apart from today.
4th.
Please.
102.
One request. Lordship may kindly recollect. This is a
One sec.
Yes.
102. 4th at 2:30.
Lord, this is a withdrawal of prosecution case PIL, my lords. Lordship, the other day, my lord, by consent, it was fixed on 8th of April. Website shows on the 3rd of April, my lords. I've spoken to learned government advocate. 8th, your lordship, may. 3rd, 2:30 is the actual date.
On 3rd, we'll put it on it. There is no need to memo. Remind on that.
Very.
Serial number 76, my lord. With regard to amendment of 128 EA, my lord. Earlier, my lord, senior counsel had appeared and requested at 2:30 today, my lord.
76.
2:30.
2/3. Or on 9th. On 9th at 2/3.
9:30. Very short.
You for it.
2:30.
Lord,
One single judge directed to
Pardon?
provide all consequential benefits upon the reinstatement. One single judge directed the respondents to provide all consequential benefits upon reinstatement. But they are not considered my referring to the
After when? After either you wait for regular listing or in June.
3 months before.
He said, you want to wait for regular listing or if we are going to give the date, it will be on 9th June. 9th June.
Lord, serial number 40, my lord. I'm appearing for the respondent. Requires some time to file my statement of objection. I have informed the other side. Serial number 40,
11th June.
please.
My lord,
Lords.
contempt petition it is. My lord, this honorable court has passed necessary order and the respondents have disobeyed the order. My lord, now they are suffering without salary, they are facing lot of hardship, my lord. Kindly it can be taken tomorrow, my lord. Necessary IA application has been filed.
3rd June.
Lords, if
My
I
lord.
may be,
You can wait. It will be listed earlier.
Much obliged.
So then give you back the memo.
Lords,
Remove the office of listener, it will be listed earlier.
My lord, it has been listing all the hearing date, but it is not at all reaching the
Then
Yes.
date must have been given.
16/6 it has been given in
15th of
June.
June. Then file IA.
We have filed already IA, we have filed for early hearing, my lord.
Post it.
Much obliged.
My lord, on contempt petition, my lord.
Yes, madam.
My lord, serial number 12, my lord. My lord, I'm appearing for the appellant. It's relating to that bank guarantee matter, my lord. We engaged senior counsel Yanchinappa. Today, there's some personal inconvenience of the senior counsel, my lord. A date may be fixed.
Now you are being informed.
Today,
You are not informed about the asking of date.
no, I will.
Now it is being informed.
No, there's this personal inconvenience for the senior counsel we have engaged, my lord. A date may be given, my lord.
11th June.
No, my lord. Earlier date because interest has been charged, my lord.
7th April.
Yes. Much obliged.
My lords.
My lord, on contempt petition, my lord. 43. Today I filed the vocal for respondent. I pray for time.
Praying for time,
Yes, like today I filed.
as
the vocal.
requested by Learned Advocate Mr. Srinivas K, 10 to 12th June. Yes.
Well, on content petition, there was a direction from this lordship to comply the order of the Honorable Writ Court. If he is not complied, I am at liberty to reopen the case. Still, he have not complied. Hence, I filed the application to recall the order to reopen the contempt. Very long back, 6 months back, I filed this application. Still, it is not yet posted in lordship.
We posted, wait for some time.
My lord,
Wait
No,
for a
6
week,
months
then,
back, I filed the application. No.
wait for some time, it will be posted.
I may be allowed, my lord.
My lord,
Number 10, my lord.
Wait after a week, you again mentioned about memo. Yes, if not posted.
My lord, serial number 10, my lords, I appear for the appellant. My lords, the arguing counsel has some health issues, my lords. He is off for some time, my lords. May I kindly,
Said that the council who is to conduct the appeal is in indisposed health. In that view, stand over to 13th of June,
please, my lords. My lords, in commercial law,
as requested.
commercial appeal.
Comma as requested. Yes.
Yesterday, this matter was listed at the serial number 107. But this matter did not reach.
Then wait will be given.
No, it has been adjourned to the 4th. So what has happened,
My
that the
lords.
Karnataka state government without issuance of.
You could have taken early date yesterday.
There is a biggest scam in the Karnataka.
You
state
could have
government.
taken early date yesterday by asking the court officer or by mentioning. Now, for such purposes, memo, if we are going to accept, then every matter of yesterday will be subjected to memo. That is not permitted.
My lords.
My lords.
commercial
My lords, with your
see-
lordships, kindly.
What has happened in this case? That without issuance of tender notification to anybody, the straight away Karnataka state government. has-
Whatever it is, you could have mentioned yesterday if the matter was posted.
I have mentioned, my lord. I have mentioned.
Then there is no memo. Then we must.
My
My
lords,
lords, my lords.
For end of the list.
Not.
My lords, commercial appeal, my lord.
Okay, my lord.
File I.
One
My
submission.
lord, there's a commercial appeal, my lords.
Yes,
The-
Mr.
My lord, serial number 24, my lord.
24.
Came, Vasant Kumar is my colleague. His father was very serious, therefore he has gone to his native, my lord. Therefore I am praying 2 weeks time.
It can go after now. After holidays, 6th of June.
My lord, serial number
My
66,
lords,
my
serial
lord.
number
Serial number
46. Serial number 46, my lords.
Yes, Mr.
My lords, for the viewing memo, my lords, the commercial appeal, they've already filed execution in the commercial court, my lords. So they'll be issuing a warrant in 5/4, my lord. So by the time we want to post a matter as soon as possible.
Warrant is 2 weeks.
Warrant will be- No, it's on 5/4, my lord. Trial court.
So 7/4,
My lords, 1/4, my lords. Okay.
1/4, 7th of.
My lords, serial number 46, my lords.
Serial number?
Serial number 46, my lords, for complainant. Yesterday, they have served their objections upon us. So we need some instructions, my lords. Kindly have it on.
You are for complainant.
Yes, my lords.
Let it be called out. It is complied with.
My lords,
It is complied with.
complaint. Complaint, it's,
Order
other
is
side.
complied with.
My lords?
Order is complied with.
Yes, my lords.
Then wait.
My lords, with your lordships, kindly have it on.
Remain present when it is called out. We'll see at that.
My lords?
When it is taken up, you remain present. We are not granting time.
We are complainants, my lords.
We are not granting time. You remain present when it is taken.
My chops.
At
My
that
lords, with
time,
your
you-
lordships, kindly.
Yes, madam.
Serial number 9, my lords, I appear for the petitioner. My lords,
Serial
I'm
number
requesting serial number 9, my lords.
9.
My lords, your lordships may have it after vacation, my lords.
After vacation, at the request of learned and petitioner, stand over to 10th June.
Very well. My lords, similarly, serial number 69, my lords. I appear for the appellant in the matter. I've informed the respondent's counsel.
Yes. The same at the request of learned and petitioner. Appellant, Tara BG. 12th June.
Very well. I'm grateful.
My lord, serial number 66, my lord. Serial number 66. And for the appellant, my lord, we've engaged senior counsel. Serial number 66, my lord, for the appellant.
66.
We've en-
So you are visible in
66.
one screen, but not visible in others.
oh, my lord. My lord, kindly an adjournment, my lord. The senior counsel that we have engaged has an inconvenience today, my lord.
All right, 13th June, as requested by learned and appellant on the ground of unavailability of the learned senior advocate who will be conducting the matter.
Much obliged.
Any mention other than Contempt matters. Serial number 1, Mr. BC Venkatesh.
Appear for complainant. Today may not posted for complaints.
Yes, where is the order? Notice returnable on 12th.
Melots, complaints of it, I'm filing that.
In fact, my lord, there is no
There,
compliance at all. They were.
That sought for bifurcation of khata, that has been rejected, Melots, as per the circular which is issued by the BBMP commissioner. I filed that this was also intimated to them last year, October itself, registered post.
The direction is.
Lord, there is a,
On a single judge dated 15th February 24.
Lord, by way of stay, it may not have purchased. Now they rejected my kata.
Was for deciding the, for adjudicating the, for deciding the application of the petitioner,
In fact,
which
my
was,
lord,
which was regarding petitioner supposed to be a request for change of khata. In response to the, not in response to. While the contempt application is, contempt petition is filed in respect of the alleged non-compliance thereof, by filing affidavit today, learned Advocate Mr. Prashant.
Yes, please.
So the respondent has produced along with the affidavit, endorsement dated 10/10/24, whereby the request of the petitioner for bifurcation of the khata has not been exceeded to post of the said order of Assistant Revenue Officer, Bureau Bengaluru Mahanagarpalika is served on the counsel for the petitioner along with the service of compliance affidavit. Also, the factum of passing the endorsement is not disputable by the petitioner in the aforesaid view.
liberty may be reserved to challenge my lord the endorsement.
The compliance is done. Contempt petition does not survive. It is accordingly disposed. It is accordingly disposed of as not surviving. At the request of learned advocate, Mr. So-and-so, the petitioner, made at this stage, it is observed that the petitioner will be at liberty to challenge the endorsement in question by instituting appropriate independent proceedings in accordance with law, in respect of which this court does not express any opinion on merits.
Please, much, much.
Serial number 2, KP Bhuvan for the
In
complaint.
this matter, my lords, we have filed a review petition. We have filed review petition, my lords. It will be listed in a week's time.
Learned,
Make submission, my lord. Last occasion, it took time to file review petition, my lord.
We have
The order
filed-
passed by this honorable court, the same, learned a single judge, 11th December 2023, my lord. 1.5 years elapsed. Only all formalities completed by the revenue officials, my lord. Only durest work, my lord. I sought for the writ of manifesto conducting the durest work, my lord.
My lords,
Till
it's-
today, they are drag on the matter. Behind the back of the, some of the people is there, my lord. Therefore, he is drag on the matter, my lord.
40 acres
Even the
of
last
government
occasion, he
land.
took time to file review petition. Even today, he is not filed the review petition, my lord. Or comply the contempt, my lord.
It's filed, my lords. It's filed, my lords. Review petition is filed.
There is no interim order.
this is order of 20th. He is right.
Please, my lords, it's 40 acres of government land, my lords. Some time may be
Only
granted.
duress
plus
work, my
review-
lord.
that-
There is
review
no
peti-
bar to comply the order, my lord. Everything is, formalities is over, my lord.
In the last order, it was recorded. The statement in the last order, it was recorded that decision was taken to file review petition by the state government. Also, when the contempt petition comes up for today, learned additional government advocate Pramodini Kishan states that the review petition is filed. On the other hand, learned advocate Mr. So and so is justified in raising a grievance that the order required to be complied with is of December 2023, and despite passage of 1 year, it is not complied with. Full stop. However, it would be appropriate in the circumstances. It would be appropriate in the circumstances to observe that the respondent state shall obtain appropriate orders in the review petition, failing which within 1 week, failing which on the next day, full stop. This was on 6/3. Today we are on 3 weeks have passed. Failing which the respondent shall remain liable to be comply with the order, and the compliance shall be reported on the next date. Put upon, today is put upon 15th of April.
Please.
We are taking much time.
Lots.
You are sitting tight for 1 year for the order. That's 40 and Durust. Not done anything.
Lots, we have worked hard to file.
When the content file, you file a review.
But in this case, appeal for the complainant, my lord.
Number 3.
The violation of order is, my lord, is annexure A, ink page 9. Operative portion is, my lord, at page number 13, para 4, my lord. If my lordship permit me, I'll read, my lord.
Notice returnable on.
Great.
13th June.
Number 4.
My lords, I appear for the complainant in this case, my lords.
Learned advocate Ms.
Kumari M.
Kumari M, who appears through video conference. Full stop. Notice returnable on 29th of April. Learned additional government advocate Srimati Nilofar Akbar accepts now. This pensionary benefit.
Yes.
Published, my lords.
Number 5.
Complaint,
Notice returnable on 6th of June.
Next matter also same. Direction to consider representative.
Same, 6th of June.
Number 7. Mr. Manjunath N, the PA.
Lord, the arguing counsel says that he has some personal difficulty. He is out of station.
My lord, similar matters, my lord has posted it on 21st of April. My lord, this may be called along with WP 33276 of 24 and 32662 of 24.
332 of 24.
32662 of 24, 33276 of 24.
Taken down the number to be listed with such and such matters which are cognate according to learned additional government. Srimati Akbar. On 21st.
Of April, my lord, it pertains to alteration of water course.
Yeah. Lord, your lordship would recall, my lord, where our mining, my lord, have been suspended. That is with regard to that Kapatguda Wildlife Sanctuary. The last location, the learned ASG But he had.
Lord, Lordship had directed implement of the National Board for Wildlife, because under 26A3, the state government cannot change the boundaries without the recommendation of the National Board for Wildlife. In one case, my lord, the National Board for Wildlife is already implemented as respond number 10. In the second case, my lord, 8.1, they need to be implemented. Lordship
But
may issue
we'll
directions.
amend it,
Amend the cost title.
we'll amend, if your lordship permits, my lord, we'll amend the cost title in that one.
It is permitted or not?
The Lordships issue directions only in 8. Now, similar directions for arraying National Board for Wildlife will also have to be issued in 8.1 as well. And my lord, I'm yet to secure instructions from the National Board for Wildlife. If your lordships call this after 2 weeks, my lord, I'll secure instructions on whether they have made any recommendation or not.
At the request of learned senior advocate, Mr. so and so for the petitioner, National Wildlife Board,
National Board for Wildlife.
National Board for Wildlife
Correct, huh?
shall be, is permitted to be completed as respond number 9.
Other 9 or
8.1.
Allapa, respondent number.
10.
Whatever, at the respond,
Indran kuda.
as respond number
10,
11.
10, respond number 10.
Is already amended.
In serial number 8, my lord, it has been done.
In 8.1.
In 8.1, your lordships were yet to issue directions to implement.
8.1, 26096. As respond number so and so, that claim. Notice shall go to the respondent.
Yes.
You are accepting notice.
I'll accept notice.
Done at the additional. pencil
Vinay
slot.
Venugopal, my lord, CGC. I'll mention, my lord. Vinay Venugopal.
Mr. Gopal accepts notice.
Okay.
Returnable will be after.
My lord, 16th, my
sec-
lord, it's some urgency for us, my lord.
16th,
Otherwise, I won't have 16th, my lord, because
20
we are
20
now not doing anything.
29th of April.
29th April, not.
My lord,
Where?
in the 24th, that week, my lord.
24th,
Lord, yes.
24th April.
24th, very well. I'll secure instructions by that.
Interim order may be extended or so that, in spite of that interim order, they are not allowed to do the work. That's why
They are
urgent.
limited,
Yes,
they are limited interim orders.
In the
Yeah,
other one,
limited,
there is an
limited.
interim order, but first one, it is not there. Last time, your lordships had extended 8.1.
ಹೌದು.
Like 8 or 8.1.
ಇಲ್ಲ, ಇಲ್ಲ.
Interim order which has been operating in the writ petition number 26096.
2609.
Shall continue to operate till the next date of it.
Please.
Nine and 10 are urgent. Seal number 11, Mr. Dhirendra V. Kuber, party in person.
My lord, we are the appellants in this case, my lord. We had preferred a writ as assailing the plan sanction given by the BBMP authorities in our area, which is a purely residential area, my lord. We had preferred this writ petition in 2024 after 2 rounds of appeals in the Chief Commissioner's office. The single judge order says that we have approached this court belatedly and without giving a chance to describe the merits of the case, it has been dismissed that we have delayed it, my lord. And we have provided a detailed timeline in the synopsis, my lord. We have not delayed the proceedings, my lord. We were constrained by the COVID-19 SOP till March 2022, my lord. As soon as the social distancing norms were lifted, my lord, we acted upon it. But however, the BBMP respondents, they were lethargic and didn't take quick action. And due to their inaction, my lord, the impugned building has been completed, my lord. And the judgment, what we have cited, my lord, were relied upon by this honorable court in the divisional bench, stated that if the authorities have given any sanction plan or order, which is violating the said law, need not be disposed of based on only the delay, my lord. Hence, we are praying this honorable court to consider the matter, my lord.
You are for state.
I am for the state, my lord. BBMP is the buildings plans and
Third learned party. Third learned party in person, Professor Dr. Dhirendra V. Hubai. Petitioner party and learned additional government advocate. Mr. Hari,
for respondent number 1, my lord.
for respondent one state, who appears upon service of the copy of the appeal in advance. What is sought to be called in question by the petitioner party, learned petitioner party in person is order, judgment and order dated 13th January 25 of learned single judge, whereby the petition filed by the appellant, original petitioner, filed by the party in person, came to be dismissed. Post of in the writ petition, comma, the petitioner had challenged and had prayed to set aside the sanctioned commercial residential building license plan dated 28/5/2020 by respondent number 4, the assistant director, town planning West. While dismissing the petition, court weighed with learned single was that the plan was sanctioned as back as in the year 2020, and that the building has also come up.
It's come up, my lord, but the commercial portion has not been occupied, my lord. That's why we have sought an interim.
Building has come up. It is recorded by learned single judge that about the sanctioning of the plan, the petitioner was aware and that he had made several representations to the authorities, representing complaints regarding deviation from the construction. Since the petition was filed after lapse of 5 years, from a learned single judge did not thought it fit to entertain on the ground of delay and on the ground that the petitioner, despite being aware, did not choose to come to the court immediately. Full stop. While learned party in person, Pereira would submit. While would admit that the building has come up, he submitted that some portion of the commercial building, some part of the building which is for commercial use has not been so far occupied. Be that as it may, full stop. It is to be noticed that while not entertaining petition, from a learned single judge has adopted a balanced approach by observing that the dismissal of the petition shall not construe to confer the legitimacy on the building is constructed if the construction is in contravention of the terms, contravention of the sanctions, contravention of the conditions of the sanctioned plan. Full stop. Learned single judge has obligated the Bangalore Mahanagarpalika to initiate appropriate action. If initiated, to conclude the same in respect of the alleged deviation from the plan. Full stop. While the court does not find any good ground to interfere with the order of learned single judge, the appeal is dismissed
My lord, can I make one submission, my lord?
with reiteration that it will be that the BBMP shall look into the aspect of deviation of the plan, and if found, shall carry out the directions of learned single judge.
And Malleshwaram is a purely residential area, my lord. This court has held in 3676 as such, my lord. That is why we are living in a peaceful residential area, my lord. Please reconsider, my lord. Much of it.
12 is urgent, seal number 13. Mr. KP Bhuvan.
Counsel for the appeal. This is squarely covered, my lords, by my lord's order. Passed, my lords, in writ appeal 254 of 2024. This is a case where, my lords, my application before the assistant commissioner is allowed. Though, my lords, this decision of this honorable court, my lords, is noticed. However, my lords, the learned single judge, my lords, proceeds to quash the assistant commissioner's order. Lords, kindly come to my lords page
Where is that?
26, my lords. The third direction, my lords, is that however, the matter stands remitted back to the assistant commissioner at page number 26, my lords. However, the matter stands remitted back to the assistant commissioner for reconsideration of the question of maintainability of the petition before the assistant commissioner in view of the observations made herein above. This would also enable an opportunity to the private respondents herein to contest the matter. The order of the assistant commissioner dated 5/4/2022 is also accordingly set aside while remanding the matter back to the assistant commissioner. No, nobody had challenged, lords. That was not the subject matter of the writ petition, lords, where I only challenged. lords.
Agreed by clause number 3, remand.
Please, lords.
Or learned advocate, Mr. For the petition, for the appellant, while challenging the judgment and order of learned single judge dated 13th February 2025, whereby the petition of the respondent, original petitioner was allowed in part, more particularly, direction number Roman small 3 of the operative part, reliance was placed by learned advocate for the appellant on the decision of the division bench of this court in Sri K. Lokesh versus Bangalore District Maintenance and Welfare Parents and Senior Citizens Appellate Tribunal and others, which was writ appeal number 254 of 24, decided on 20th December 2024, in which a clear and categorical view is taken that the
Para 46 and 50.
appellate remedy under section 16
Please, my lords.
of the Act Pura Naam Act,
Para 46 and 50, my lords.
Maintenance and Welfare of Parents and Senior Citizens Act 2007 cannot be invoked, can be invoked only by the senior citizen or a parent. Full stop. Prima facie, this dictum of law laid down by this court has been ignored by a learned single judge in remanding the case. Full stop. Appeal is admitted, impugned judgment and order, insofar as it relates to direction number 3,
Please.
Roman small 3 of the operative part, in the operative part, shall remain state.
Please. Lords, there is an observation, lords, that could continue, lords. In the order of the learned single judge, lords, the last observation, lords, is that the respondents shall not alienate the properties, lords, is there.
Lords, at page number 26.
Page number?
After that, my lords, needless to observe that the private respondent shall not deal with the property or alienate the property in dispute till the reconsideration at the hands of the assistant commissioner, my lords, is the observation made, my lords.
Then entire. So we'll say entire judgment, stay of the judgment and order. There shall be the judgment and order of Learned Single.
Lords, that is in my favor, my lords. That observation is in my favor.
Which one?
My lords, the last observation.
So you want to number 2 also? to be
Only,
stayed?
only 3, my lords, only 3, my lords, only 3.
That is what we have done
Please, please.
earlier.
Grateful.
Number 14.
Lord, I appear for the appellant. What has happened is, my lord, there was an appeal filed after 7 long years. I was granted a land. 7 long years, my lord, the appeal was filed. Assistant Commissioner, my lord, condones the delay, saying that, my lord, there is no appeal, no, there is no provision for, my lord, delay at all. My submission to your lordship is, my lord, please come to, my lord, the order passed by the Assistant Commissioner, which is at page 37, 37, my lord. At 38,
One second. Page
37, my lord.
Yes.
At 38, my lord, can I persuade your lords to look at 38, my lord? Observations. In the middle, my lords get observations. Considering the above arguments, the following points are observed. As per the published judgment of this Honorable Court, High Court, in the case of Kingfisher Airlines versus IT Department, grant made in favor of the original guarantee after a lapse of 23 years is concerned. It can be seen that there is no limitation period. My lord, please look at, my lord, section 51 of the Land Revenue Act itself. 40, my lord, 2 months, my lord, is the limitation. Section, my lord, 51 of the
Limitation for?
my lord, for filing an appeal. This gentleman not files an appeal. My lord, what had happened was I was granted a land. There is some dispute between me and the other side. They are not even, my lord, allowed, my lord, grant.
Site is granted in some government layout.
Yes. Then, my lord, the respondent files, my lord, an appeal. He is neither, my lord, an allottee or, my lord, my rival, my lord, he is not even asked for any allotment. He files, my lord, because, my lord, there's a suit between us in relation to some other thing. He, my lord, files an appeal under section 49. My lords get that, my lord, section 49, that he has filed that appeal. Please come to, my lord, running page, my lord, 57, my lord, if your lordship sees. Section 51, my lord. Please look at section 51. No appeal shall lie in the case of first appeal after the expiry of 60 days from the date of the order appealed against. In the case of second appeal, after the expiry of 90 days from the date of the order appealed against.
Limitation Act is made applicable.
Yes, my lord.
Section
Limitation Act is made applicable. The Estate Commission, there is no limitation at all. And, my lord, this is an appeal file. Therefore, my lord, I am before your lordships. Learned single judge has not considered this. Page, my lord, 57, if your lordships come to 57.
Yes.
My lords get, my lord, as per section 49 of the rules of the Karnataka Land Revenue Act, file the appeal. Section 49, my lord, is the first appeal. My lords have seen, my lord. First appeal is 49. 51, my lord, is limitation. 7 years later, my lord, he files it. The tribunal says there is no limitation at all. Learned single judge, my lord, says, my lord, my wife was allotted something. But, my lord, my submission to your lordships is, even, my lord, in case, my lord, of any other fraud also, there has to be, my lord, some, my lord, timelines. That is what, my lord, the Honorable Supreme Court has held.
Some fraud is alleged.
Please, my lord.
Some fraud is alleged.
My lord, fraud in the sense, my wife was allotted some land. Therefore, my lord, he says fraud. My submission is, the tribunal did not go into it. It condones a later after 7 years. I've constructed a house. 7 years later, my lord, Can I request your lord to look at, my lord, just one judgment of the Honorable Supreme Court? Even in case of fraud, it has to be, my lord, within 3 years or within some reasonable time. Please look at, my lord, 2015, 3 SCC 695, paragraph 25, my lord. Please come to, my lord, paragraph 25 at running page 14, my lord, 1-4. Legal position is fairly settled by a long line of decisions of this court, which have laid down, even when there is no period of limitation prescribed for exercise of power, revision or otherwise, such power must be exercised within a reasonable period. This is so even in case where allegations of fraud have necessitated the exercise of any corrective power. We may briefly refer to some other decisions, but they refer to various decisions. My submission to your lordships is, he is my lord, he has no locus at all. Nothing is considered. Straight away, my lord, 7 years delays condoned. He doesn't even, my lord, give any reasons.
He was in third party, outsider.
Yes, my lord. He has nothing, my lord. There is some litigation between us. No? He files it.
Lord, this is at the this is at the instance of a third party, my lord. The appeal has been filed.
So he was a busybody.
My lord, what has happened in this case, my lord? There is an allotment both to husband and wife, my lord, which is contrary to the scheme. Both husband and wife have availed the site, my lord, which is
constructed a
meant for
house
landless
after
people.
7 long years. It's
True, my lord, but it's meant for landless people, my lord.
And
Both
it can't
husband
be
and
that,
wife
my
have availed the benefit by suppressing the fact. The observations are at paragraph 6 may kindly be seen.
While assailing the judgment in order of Learned Single Judge dated 19th February 25, impugned in the present appeal from a learned senior advocate Mr. Uday Holla for the appellant original petitioner, submitted that single judge committed a manifest error in upholding the order of the assistant commissioners, allowing the appeal of private respondent number 3 herein. It was submitted that the appeal was filed under section
49
49
of the Land Revenue, Karnataka Land Revenue Act.
Karnataka Land Revenue Act, and under section 51, the limitation for preferring the appeals are provided, which in case of first appeal is 60 days and in case of second appeal 90 days. It was submitted that the appeal before the respondent number 2 assistant commissioner was delayed by
7 years.
7 years. Full stop. He took the court to the dealer convention application, which on the face of it, too cryptic to be countenanced for viewing the delay in any lenient manner. Full stop. The dispute paragraph related to allotment of 2 sites to the petitioner, which was sought to be called in question before the respondent authority by a third party, respondent number 3 hearing, which resulted into the aforesaid order brought under challenge before Learned Single Judge. Full stop. The period 7 years, it could be rightly submitted by learned senior petitioner that period of 7 years, as was rightly submitted by learned senior to the appellant, is too long a period to be overlooked, even if, for the sake of consideration, the allegations were in relation to the fraud. Full stop. In this regard, learned senior advocate relied on the decision of the Supreme Court in Joint Collector Ranga Reddy District versus D. Narasimha Rao, 2015, 3 SCC 695, to rely on observations in paragraph 25, which are raised under. So, 25. A strong prima facie case is made out. The appeal is admitted. Impugned judgment and order shall remain state.
Stay of the order passed by the.
Appeal may be listed for final hearing on 23rd June.
Not stay of further proceedings before the Assistant Commissioner.
Day of proceedings before Assistant
Assistant
Commissioner,
Commissioner.
Stay
otherwise.
of ad interim leave, there shall be,
Please.
shall be stay of the further proceedings before.
Assistant Commissioner. my lord.
Annexure.
Page 100, my lords get that, my lord.
But then now they are proceeding further.
My lord,
Yes.
delay is
Yes.
condoned now, my lord.
Delay is.
Proceedings are
Ah,
pending, my lord,
proceeding.
as on, it's against the condonation of delay, they had filed the writ
Therefore,
petition.
proceedings are to the state. my lord.
This is for condition.
Condonation of delay, they had challenged.
Well, appropriately alter it. There shall be no further proceedings before the assistant commissioner.
Please, great.
During the pendency of the appeal. The appeal may be listed for final hearing on 23rd June. Yes. next.
Nothing will be
Fine.
present in this case, my lord. Just now, my learned friend saw the
My lord.
affidavit, my lord.
Make one submission, my lord.
Yesterday.
We have engaged my senior counsel.
Yesterday.
Is- Please, my lord. We have engaged the senior counsel, Mr. TL and Rao, my
Yes,
lord.
sir.
Please, my lord. My lord is directed to keep present
This
the.
appeal.
Oh, yes,
Appeal
my
is-
lord.
This for
Yes, my lord.
My lord,
Appeal.
will be taken up contempt.
May
my
one
lord.
submission, my lord. My lord, morning I get the information, my senior is not hospitalized. May request for Monday, my lord.
Writ appeal may be postponed, my contempt may be taken up, my lord. Contempt, my lord, he's just served the complaint affidavit, my lord. In that nowhere it is says, my lord, continue my services, my lord. Only who originally came to my place, my lord, he have transferred back to his place. But in complaints affidavit, my lord, is not showing that the complainant should be continue in the services, my lord. Contempt may be taken up today, my lord. Since from
So
8
you are
months,
the-
my lord, I'm.
My lord.
You were asked to find out some way.
My lord, please, my lord.
That-
That's the reason, my lord, we have replaced the original permanent employee to same, earlier he is working in the same place, my lord. We are accommodating
Sir,
Please give the feed. think, because there is a symbol, I think now it has been unmuted. They were not able to hear the court.
Feedback.
But your matter starts now only. Yes. Yes, Mr. Dawar.
We always enjoy hearing the proceedings. So
Thank
your
you, thank
lordships have deprived us the opportunity of hearing the earlier proceedings.
Thank you, sir. Yes.
Grateful, my lord. May it please your lordships. My lord, I had stopped yesterday at paragraph 269 of my lord Vijay Madan Lal Chaudhary. So may I kindly invite your lordship's attention to that. That separate copy, which was given by Miss Athirishi.
Yes.
Para 269, we were. Now, my lord, this is important for this reason that, my lord, reason to believe is linked to section 3. My distinguished friend argues that the learned judge takes a view and is trying to read into reason to believe many things. That's not true, because section 3 is, my lord, is the real section. It's like a charging section in a taxing statute. Section 3 is the charge of criminality and the power or jurisdiction to enter upon an inquiry. So please see, my lord, para 269, last sentence. Para 269, last sentence where we had stopped yesterday. Thus, offense otherwise has nothing to do with the criminal activity relating to a scheduled offense, except the proceeds of crime derived or obtained as a result of that crime. Then your lordships may see paragraph 271 at the foot. Para 271, my lords. As mentioned earlier, the rudimentary understanding of money laundering. Now see, this is very interesting. Rudimentary understanding of money laundering is that there are 3 generally accepted stages to laundering. They are placement, which is to move the funds from direct association of the crime. Now, my lord, that's not the case here. There is no funds which have been moved from the crime to anybody else. B, layering, which is disguising the trail to foil pursuit. And C, integration, which is to make money available to the criminal from which seem to be legitimate sources. Then para 272. It is common experience world over that money laundering can be a threat to good functioning of a financial system. Para 272, my lord.
One.
But as I said, section 3's debate starts at page 263, para 263 onwards. But we are reading para 269, 271, 272.
Yes.
My lord, the Chief Justice has, my lord, para 272 now.
Yes.
It is
common.
Yes, ma'am.
Yes.
It is common experience world over that money laundering can be a threat to good functioning of a financial system. However, it is also most suitable mode of criminals in such money. It is the means of livelihood of drug dealers, terrorists, white-collar criminals, and so on. Pause here, my lord. Just pause here for a moment. Kindly, my lord, appreciate this. Here is a case where government is giving the plots to the landholder. Where is the question of money laundering here? The government, Lord, it may be a wrong decision. It may be a decision which is against public interest. But there is no money laundering here. There is no money which is derived from criminal activity. Therefore, there is no proceeds of crime, which is condition precedent. The plots are given in lieu of land acquired without authority of law, because no compensation was paid, admittedly. So the plots were given, and that too, my lords, plots were given to Srimati Parvati. I, as a commissioner, have nothing to do with it, my lord. Why am I being dragged into this controversy? What I have done as a commissioner is what the rules provided, what the resolution of Muda provided. I was not a party to them.
Only to understand, which may have nothing to do with this matter. The proceeds of crime is not limited to money.
No, not necessarily. Your lordships are right.
Correct.
That those may have been converted. Your lordships are right.
No, even the definition and the sections which speaks of proceeds of crime doesn't refer to money part only.
No, I'm not saying that. For a moment, I'm not
Yes.
saying. Your lordships are absolutely right. My lord,
Yes.
it can be in any form. It
Yes.
can be in the form of, my lord, property. It can be form, but it must be proceeds of crime.
That's
What my emphasis is, my lord, that there is no proceeds of crime here.
There you are right, yes.
Here the plots, let us assume plots are money. Let us assume. But those plots have not been derived from a crime. Those plots were given by government as part of a statutory exercise, a policy decision of Muda, in lieu of land which is taken over by government without paying compensation. Which, my lord, your lordship's court has upheld again and again. I will read, my lord, Justice Nagaratna's, my lord, judgment as ladyship was in Karnataka High Court in the division bench. There, my lord, the division bench sustained 15 plots allotment. And, my lord, said single judge was absolutely justified in giving the plots. Another division bench headed by Justice Ravi Math, as lordship then was, also said, yes, plots have to be given. And a third division bench, my lord, took that view, against which SLP has been dismissed by Supreme Court. So, my lord, this allotment of plots is part of government's policy. It's a statutory exercise. It's a policy exercise. It has nothing to do with a crime. And it is irrespective of, my lord, political party. Janata Dal government has given, Congress government has given, BJP government has given. So is the ED going to reopen all those millions of cases and say that these are all proceeds of crime, therefore we will go after innocent citizens? That is the question before your lordships today.
Yes.
So, my lord, para 272. Tainted money breeds discontent in any society and in turn leads to more crime and civil unrest. Thus, the onus on government and the people to identify and seize such money is heavy. If there are proactive steps towards such a cause, we cannot but facilitate good steps. So, my lord, why did the court justify it, this law? Because to fight, my lord, drug dealers, terrorists, and white-collar criminals. My lord, an innocent action by government is not to be treated as a, my lord, crime. However wrong it may be, however unpalatable it may be. Somebody just after 15 years files a, my lord, complaint to Lokayuk and ED swoops into action and says thousands of plot holders, now you come and we are summoning you under 50, make statement. No, my lord, that's not the power. That's not how Vijay Madan Lal Chaudhary should be read. It is read completely, and learned single judge has very rightly read that. I will show, my lord, learned single judges. It's an eminently just judgment. Now see next sentence, my lord. Last sentence of para 272. However, passions aside, we must first balance the law to be able to save the basic tenets of fundamental rights and laws of the country. After all, condemning an innocent man is a bigger misfortune than letting a criminal go. Please say this, my lord. Is ED, my lord, weaponized for the purpose of harassing innocent citizens? And selectively, my lord, learned Judge Justice Nagaprasanna, my lord, another petition was filed by the same petitioner, public spirited. My lord, the day after the judgment came, where section 17A, permission by Honorable Governor, was, my lord, approved by the High Court. He files a second petition next day saying, now transfer it to CBI. That was dismissed by learned single judge. And in that, learned single judge records that there are as many as 38 cases pending before Lokayukt court against top politicians of BJP, Congress and Janata Dal for last 30 years, 25 years. One chief minister, former chief minister, is facing 11 inquiries. So you don't proceed against them. ED has nothing to do with them. But ED comes in here. Now that's not something I respectfully submit. Your lordships is not just a court of law. Your lordships are a court of equity as well. Your lordships are there to protect constitutional rights of citizens. And your lordships therefore would err on the right side of protecting rights rather than allowing a flimsy inquiry and harass innocent citizens. That is what this para says. This is not some drug money. Now see, my lord, kindly turn paragraph 282 straight away. Para 282. Be it noted. Now see, my lord, this is where my distinguished friend makes an error that learned single judge has gone overboard. My lord, my learned friend used the expression judgment is perverse more than 17 times in his arguments. I was counting. It is not a perverse judgment. It is an extremely erudite, a good judgment laying down correct law following Supreme Court judgment. Please see now what 282. Jurisdiction. Be it noted that the authority of the authorized officer under the 2002 Act to prosecute any person for offense of money laundering gets triggered only if there exists proceeds of crime within the meaning of Section 21U of the 2002 Act. Further, it is involved any process or activity, not even in a case of existence of undisclosed income, and irrespective of its volume, the definition of proceeds of crime under Section 21U will get attracted unless the property has been derived or obtained as a result of criminal activity relating to a scheduled offense. But if a government takes a policy decision and that decision is implemented for 3 decades by every government, every authority, my Lord Justice Arvind will inform your lordships that every statutory authority in Karnataka, whether it is Bangalore Development Authority, Shinmoga Authority, every authority has followed this policy of allotment of plots. Are we going to reopen those cases and not condemn people under this act? That, my lord, is something which is a very serious issue. After all, my lord, that's why I said, as Justice Chandrachud very rightly points out in Minerva Bills, my lord, only Articles 14, 19 and 21 stand between that, my lord, dream of Ravindranath Tagore. So, my lord, I suggest your lordships may kindly see what is happening. Now, please see next page, a para 232, 283, sorry, 283. Even though Act is a complete code in itself, it is only in respect of matters connected with offense of money laundering, and for that existence of proceeds of crime within the meaning of Section 21U, Act is quintessential. Money laundering. Lord, government scheme is not a money laundering scheme. It's a statutory scheme under a statute. Absent existence of proceeds of crime, as aforesaid, the authorities under 2002 Act cannot step or initiate prosecution, cannot step in. So this is the jurisdiction, my lord. This is the authority. This is what Ujjambai, Coffee Board, and all those cases have held, my lord, for last 77 years. That if you have no jurisdiction, you can't start an inquiry. And High Court will step in and say that this inquiry must be forthwith stopped and it will be quashed. Series of constitution bench judgments of my lord, the Honorable Supreme Court. Now please see, my lord, para 284. In other words, now my lord, this is on reason to believe. My learned friend made a lot of, my lord, arguments that, oh, single judge is perverse because he says reason to believe. In other words, authority under 2002 Act is to prosecute a person for offense of money laundering only if it has reason to believe, which is required to be recorded in writing, that person is in possession of proceeds of crime. Only if that belief is further supported by tangible and credible evidence indicative of involvement of person concerned in any process or activity connected with proceeds of crime, action under the act can be taken forward for attachment and confiscation of proceeds of crime, and until vesting thereof in the central government, such process initiated would be a stand-alone process.
These observations in paragraph 284 are more relatable to the stage of section 19 or?
Yeah, but, first part is my lord 17. Second part is 19. Your lordships are right. First part is reason to believe. You can start inquiring only if that there is a reason to believe. My lord is
Because
right.
the conclusion that the one is. in
That is the
possession of
second part. Further proceed for attachment. My lord is right, absolutely. Second part is for attachment.
Correct.
So, my
Yes.
lord, you cannot enter unless you have a reasonable belief. Now, what is that reasonable belief? Just give me 2 minutes, my lord. What has the Honorable Supreme Court said, my lord? I will, my lord, just read out. My lord, Supreme Court said in, my lord, that is reason to believe. My lord, in Jyoti Prasad, I will give the citation. Reason to believe is not the same thing as suspicion or doubt. And mere seeing also cannot be equated to believe. Reason to believe is a higher level of state of mind. Higher level. This is what Supreme Court said in Jyoti Prasad versus Haryana 1993, my lord, supplement 2 SCC 497. Now, my lord, Justice D.A. Desai, in a brilliant judgment, my lord, Pratap Singh versus Director of Enforcement said this in, my lord, 1985. Expression reason to believe is not synonymous with subjective satisfaction of officer. The belief must be held in good faith. It cannot merely be a pretense. It is open to court to examine the question whether the reasons for belief have a rational connection or a relevant bearing to the formation of belief and are not extraneous or irrelevant for the purpose of section. Now, my lord, learned single judge called for these reason to believe. The ED supplied in a sealed cover. And he says that there are no reasons here. And I will show, my lord, appeal memorandum. They admit this position. Turn to the appeal memorandum at this stage, my lord. It's, my lord, I have not seen, my lord, a more greater abuse of power than this. Please turn to appeal memorandum at page 13 and 14. Why are they launching this, my lord, whole exercise against, my lord, innocent people? Lord, I'll come back to Vijay Madan Lal Chaudhary later on section 17. Just read this first, 13 and 14. What is their reason to believe? It's extraordinary. There's nothing in the case. Page 13, my lord, of the appeal memorandum.
Page
13 of the appeal memorandum.
13 of them.
FIR number, page 13, my lord.
Yes.
Lord, I must tell your lordships one thing. Article 21 has now been expanded by your lordships courts, including Supreme Court, very widely. It includes not only liberty in liberty sense, it also includes, my lord, right to goodwill, right to reputation, right to peace of mind. You can't issue, my lord, anybody who's issued a section 50 summons, my lord, shudders today with the ED coming in. Across the country, my lord, this is happening. This is a very nice way, my lord, of destabilizing governments. Why is it that, my lord, it has never happened in a single BJP state? I ask myself a question. It's only happening in opposition states. Tamil Nadu, my lord, Jharkhand, Karnataka. These are the states which are facing the brunt of ED. Your lordships have to protect, my lord. Ultimately, I beseech your lordships, beg your lordships with folded hands, that please see, my lord, the purpose behind this exercise. Now, page 13. FIR number 11 was registered on Lokayukt court at so-and-so by against Sri Siddharamaya, Srimati Parvati, Maljukarjan Swami and Sri Devaraju. You know, Devaraju is the original owner of land who's now 80 years. He sold in 2004. Poor fellow is now not facing this nonsensical inquiry at the age of 80 for having sold his land, which he didn't know that 20 years later plots will be allotted under so-and-so Prevention of Corruption Act are offenses. Allegation in FIR is that Devaraju illegally sold land to Mallikarjun Swami. Now, this is incorrect. He legally sold. They think that illegally because he was not the owner. But as my documents are now filed, brother-in-law of Chief Minister, land was subsequently gifted to so-and-so. Land was notified by Mysuru Development Authority for acquisition to form layout. Land was illegally denotified. Totally wrong, my lord. The original landowner, Devaraju, has said, requested government that please release my land. I'm a small farmer. Government released it. Nobody has challenged that denotification. And denotification in every state, especially in Karnataka, is a common exercise. It is not done for political reasons. Notify so-and-so. Subsequently, an illegal claim for compensation was made by Parvati against acquisition. What illegal? What happened was that Devaraju's name was there in record, yet he was not given notice for acquisition. The land, this Muda authority, occupied the land and have developed it. So, Srimati Parvati made a claim for compensation because it is her land which has gone, was made by so-and-so. By using undue influence of Sri Siddharamaya, who is influential politician, so-and-so 14 alternative sites in affluent developed areas are given. So, 20 years earlier, you have taken away the land. You are calculating today's value for those plots. For 20 years, you have not paid compensation. But I am not here to defend Parvati or Siddharamaya. I am submitting, my lord, that this is the fulcrum of their case. What have I got to do, an IAS officer who's discharged this duty, my lord, as per the constitution, as per rule of law, as per statutory act, as per statutory rules, and as per Muda's resolution? What have I got to do? Why should I be penalized like this and subjected to, my lord, this? Your lordships can imagine what would my neighbors be thinking when ED comes to my house. They will think that I am a corrupt bureaucrat. Why these kind of inquiries? Am I involved with some drug traffickers? Am I involved with terrorists? Am I involved with arms traffickers? So this is a serious issue which deserves your lordship's attention. That is why I had begged in the earlier round of petition, which your lordships had fixed last Saturday and couldn't be heard, that these matters require a detailed hearing at the earliest. Because those matters are not being heard, had your lordships come to the conclusion, if we were right, I mean, I'm not saying if we may be wrong, but if we were right, and if your lordships had held that the entire exercise is fraudulent, it is mala fide, it is for political vendetta, then, my lord, the whole thing would have failed. Now, why do they want stay today? That they want to issue some 100 summonses. I will show at page 25 and 26. Please see, my lord, now. Now, para 5, my lord. Just see first sentence of para 5. On the basis of above information, there was sufficient reason to believe petitioner, who was previous commissioner, is in possession of proceeds of crime. Para 5. Only basis. Where is the crime? Where is the proceeds of crime? Is this a crime? To do something which my statutory duties required me to do? Nobody will be safe, no bureaucrat will be safe. Take out Nandalal Jaiswal, that passage. Now please see page 25, 26. How seriously this is happening. Please see page 25, 26. What do they want? Why do they want stay?
Yes.
Para 19. Appellant identified other issues during search as under Now, my lord, in my search, nothing has been found except a mobile phone. Nothing. No incriminating document, nothing. Allotment of sites as compensation is covered by 50-50 scheme of Karnataka Urban Development Authorities. A rules 2009 as amended, which envisages allotment to be made in the same layout following lottery system, no commercial site. However, multiple sites have been allotted in gross violation of these rules. As per evidence gathered, 1,095 sites of allotment have been made. Allotment of 50-50 was significantly ordered stopped. However, 252 sites have been allotted subsequently. Is this a public interest litigation by ED? What has this got to do with the crime in question, assuming there is a crime? You said allotment of 14 sites to Srimati Parvati is a crime. Oh, what is this happening on in this country? We are fortunately still governed by rule of law. This is not the authority which Vijay Madan Lal Chaudhary gives to them. Now see D. Evidences have revealed that there is deep nexus of MUDA officials with private persons, business people such as real estate agent, businessmen. Allotment of site is done in collusion with this individual. They send details of sites. Some of these private individuals are relevant relatives of key MUDA official. This aspect needs thorough investigation. But will your lordships permit this by giving a stay? This is not what is not really troubling me. Why, Lord, I am taking your lordship's precious time is because of this. Because it has very, very serious consequences on liberties of citizens. Their reputation, their goodwill, their peace of mind. It's all right for you to say that this is a perverse judgment, perverse judgment, perverse judgment 17 times. There's nothing perverse about it. The single judge says you can't do this. There is no crime here. There is no proceeds of crime. You have no reasonable belief here. It's completely non-existent. Completely non-existent. Now, just note, my lord, this passage of Justice Bhagwati's judgment. Your lordship need not turn to it. Have you given this? Anisha ji, please give this authority to lordships. 1986, 4 Supreme Court cases, 612. Sorry. It is 566 at 612. But it's a brilliant passage about how governments function.
Sir, can you repeat the citation, please?
Yes, please. 1986, 4 Supreme Court cases, 566.
Thank you.
State of MP versus Nandalal Jaiswal. But this is the judgment your lordships would recall. But upturned the judgment of Justices Verma and Justice B.M. Lal of the Madhya Pradesh High Court as lordships then were, in which, Lord, the Madhya Pradesh government was indicted and, Lord, very severe strictures were made. Now turn to para 40 at page 612. Only few lines are important. Just see, my lord. Page 40, Lord, para 612, para 40, page 612. Lord, last but the 12th line. Last but the 12th or 13th line. The policy decision was informed. My lords have that? My lord, the Chief Justice have? Para 40, my lord. The policy decision was informed.
Was informed.
Yes, my lord. It begins with the sentence.
Yes, policy decision, informed decision.
Was an informed and reasoned decision arrived at after detailed inquiries, fact-finding efforts and reports spreading over a period of more than a year and a half. Several queries and issues are raised by Finance Department boldly and fearlessly. And these queries and issues are fully and finally dealt with. Clarifications given, entire matter was considered. There was no attempt at any stage to suppress discussion and debate or avoid or sidetrack, push under carpet any doubts or questions raised by parties. It is significant policy decision was not arrived at by a single individual in the secrecy of chamber, But it was done by entire cabinet and it was based on recommendations made by cabinet subcommittee, which composed of 4 ministers and officers from different departments belonging to higher echelons of civil service. It may be noted, cabinet subcommittee considered matter from different angles, obtained information, etc. The entire proceedings of cabinet subcommittee were before cabinet, including reasons for so and so. Entire proceedings show that there was complete openness of discussion and deliberation. There was no suddenness of decision, no impulsive caprice or arbitrariness in reaching decision. Policy decision was plainly and avowedly an informed and institutionalized decision. And the manner in which it was reached is clearly indicative that it was neither mala fide nor guided by any corrupt or collateral consideration. Now, my lord, policy decision here was taken when the rules were framed in 2009, amended in 2015. Statutory rules, my lord. And my lord, Mudda's own resolution of 2011, as I read out yesterday to your lordships, presided by every political party. Are you going to prosecute all those MLAs from BJP, Janata Dal and Congress for that decision? So, my lord, these are institutionalized decisions. It sometimes, my lord, they may be abused. I'm not for a moment justifying any abuse, my lord. But here is an admitted fact that plot of land was sold by Devaraju to Lord Swami in 2004 for a valuable consideration. Swami then gifted it to his own real sister, Srimati Parvati, who happens to be Mr. Siddharamaya's wife. Yet, my lord, without any notice to them, the land was taken away by Lord Mudda. Although it was, my lord, notification was issued, it was denotified. After denotification, they did not return the land. They used the land, statutory authority, my lord, Mysore Urban Development Authority. So, my lord, under the rules, if you have done that, you are entitled to plots. Plots were given. Now, my lord, this exercise is not a criminal activity. It is not a criminal activity. Now, my lord, please kindly come back to Vijay Madan Lal Chaudhary and see on section 17 what did lordship say. It starts at para 308, and I will place paragraphs 311, 12 and 15.
$312.
308 first.
8.
Last 5 lines, my lord. However, when it comes to search,
Yes.
last 5 lines of 308,
However, when it comes to search and
seizure under section 17 of 2002 Act permits only the director or any other officer not below the rank of deputy director authorized by him to exercise that power on the basis of information in his possession and having reason to believe that any person has committed some act which constitutes money laundering or is in possession of proceeds of crime involving in money laundering, including records, property relating to money laundering. So, Lord, this is your power to enter. You don't have, Lord, it's not some unbridled, uncanalized, draconian power that you just go on, Lord, fishing inquiries. This is too serious a matter, my lord. Now kindly turn to paragraph 311. And after, my lord, 7-8 lines, please read after 7-8 lines, 10 lines. Even in the matter of searches and seizure, para 311, my lord, 10th or 12th line from the top. Even in the matter of searches and seizures.
312.
Para 311.
311, yes.
For 10th or 12th line. Even in the matter of searches and seizures. My lords
Yes.
have, both your
Yes,
lords
sir.
have got.
Yes.
under the 2002 Act, that power can be exercised only by the director and so and so. They are not only high-ranking officials, but have to be fully satisfied. Please underline the words. Have to be fully satisfied that there is reason to believe on the basis of information in their possession about commission of offense of money laundering or possession of proceeds of crime involved in money laundering. But the ECIR doesn't record anything except this FIR of Lokayukt. But notices issued to me doesn't say anything about that FIR. What is happening, my lord? And my lord, argument is made that yes, I mean the single judge is wrong in insisting on reason to believe. You have no right to enter, my lord. You have no right to start an inquiry. This whole exercise is, my lord, it suffers from complete absence of authority or jurisdiction. And in my respectful submission, it suffers from malice in law, not in malice in fact, but malice in law. Because if the authority is actually exercising a purported power to achieve some other objective, then, my lord, Justice, my lord, in Venkataraman's case, the Honorable Supreme Court brilliantly said that the whole exercise is a void exercise. Not mala fide, but malice in law. Now, my lord, para 312. Para 312. As aforesaid, section 17 provides for inbuilt safeguards. What inbuilt safeguards? This is what learned single judge says. Inbuilt safeguards not only mandating exercise of power by high-ranking officials of rank of director so-and-so or so-and-so, so-and-so, but also to adhere to the other stipulations of recording reasons regarding the belief formed on the basis of information in his possession about commission of offense of money laundering or possession of proceeds of crime involved in money laundering. Now, you can't say in any case, there is, supposing, my lord, I have genuinely sold my property to X. Can, my lord, ED officer write that Mr. Dave has sold the property, there is a crime, therefore I order my subordinate officer to start an inquiry against Mr. Dave? It's not ipsy dixie. It must be, my lord, sufficient evidence in relation to commission of a crime and not proceeds of crime. So and so. Further, such recorded reasons along with materials is required to be forwarded to 3-member adjudicating authority. So and so in a sealed cover to be preserved or specified purpose, thus guaranteeing fairness, transparency and accountability regarding entire process of search and seizure. This is unlike provisions of 1973 code, where any police officer, including head constable, can proceed to search and seize records or property merely on the basis of allegation or suspicion of commission of scheduled offense. Please see this, my lord. So mere suspicion is not sufficient. That is why all those judgments, my lord, on reason to believe, my lord, are so important. Now, para 315. Why has the learned judge, my lord, given relief 4, which I have fairly said that should be stayed? And I frankly feel, although, my lord, personally, I think it is justified, I feel that it should be set aside, that relief 4. But that's, my lord, I am saying as a lord officer of the court, not on instructions of my client. Just see 315. Hmm. 315, my lord, the Chief Justice.
Yes.
It is pertinent to note that if the action taken by authority under the 2002 Act, including regarding searches and seizures, is eventually found to be without reasons recorded in writing, would entail punishment for vexatious search under Section 62 of the 2002 Act. such being the stringent safeguards provided under Section 17 of the 2002 Act and rules framed regarding process of searches and seizures concerning offense of money laundering and for prevention of money laundering, including attachment of proceeds, it is unfathomable as to how challenge under consideration can be countenanced. Why did they uphold the challenge? Because the court says that there are safeguards. Now, if these safeguards are given a go-by, as they are in this case, then broad actions become bad, unlawful, illegal. You
Yes.
can't have it both ways. You cannot say that act is constitutional and yet I will act unconstitutionally. That's not what, my lord. Now, my lord, kindly turn to, my lord, para 422 at 431. 431, my lord, on section 50. It starts at 433, 422, the debate on section 50, but para 431 is only relevant, my lord. Kindly turn to para 431.
Yes.
In the context of 2002 Act, it must be remembered that the summon is issued by the authority under section 50 in connection with an inquiry regarding proceeds of crime which may have been attached and pending adjudication before adjudicating authority. In respect of such action, designated officials have been empowered to summon any person for collection of information and evidence to be presented before adjudicating authority. Today there is nothing. Some suspicion and some bogus allegation by a public spirited citizen that there is corruption involved. The learned single judge dismissed the second petition for a CBI inquiry, saying that this is an abuse of the process of the court. You have invoked Lokayukta jurisdiction, go there. Now, my lord, I can understand after Lokayukt court, my lord, has convicted these people, then ED comes into play, if at all. Today, before Lokayukt court, summary report is given, saying there is no criminality. Lokayukt court is considering that, whether to accept and drop the, my lord, dismiss the complaint. Even if it, my lord, decides to proceed, that's not no ground, my lord. There is no crime as envisaged by the 2002 Act. Yes, the schedule has every crime. My lord, 420. Today, every day, millions of cases of 420 are registered by police. Cheating. Does it mean ED goes into every such case because it is a scheduled offense? No.
Yes.
Now, my lord, kindly turn to para 455. And they have summed it up, my lord, beautifully in this paragraph. What? 130 courts it still. Needless to underscore that 2002 Act, needless to underscore that 2002 Act is intended to initiate action in respect of money laundering activity, which is necessarily associated with the property derived or obtained by any person, directly or indirectly, as the result of specified criminal activity. So, my lord, criminal activity together with money laundering and proceeds of crime, these are three essential ingredients. The prosecution under this act is not in relation to criminal activity per se. the prosecution under this act is not in relation to criminal activity per se, but limited to property derived or obtained from specified criminal activity. Now, my lord, I have not got a single plot. What have I got to do with it?
Yes.
And ECIR, so far as Srimati Parvati is concerned, has been quashed by the learned single judge, against which they have to go to the Supreme Court. That ECIR has been quashed against, my lord, the main accused. But I am, my lord, here facing, this goes into my service record. Do you realize, my lord, what happens to officers who, my lord, diligently discharge their duties? My promotion will be stopped. Tomorrow my pension may be stopped. Don't harass people like this.
This judgment of learned single judge was before the B summary report, B report.
Yes,
Or
yes.
after?
It was before.
No, this was not dealt with by the single judge.
Yes.
Which learned single judge's judgment? Impugned judgment.
Yes.
Yes, my lord. It was before the B summary.
There's not a whisper on that.
So, my lord, this is what, my lord, this judgment says.
Yes.
And if your lordships were to read the judgment in entirety, what becomes very clear is that, my lord, the power under the act with the ED officials is not to go on a fishing inquiry and roving inquiry. It is limited to, my lord, finding out the proceeds of crime derived from a crime which may be related to a scheduled offense. And the whole purpose is to stop money laundering. Your lordship, my Lord Chief Justice very rightly said that it is not necessary that cash alone should be involved. Yes, I bow down to that. But, my lord, is it money laundering? Giving of 14 plots? Government has given. Who has money laundered? The government? So, my lord, the money laundering aspect is very important. The idea is to stop that, my lord. And as I said, my lord, the entire act was based on international conventions to fight, my lord, the menace of drug business, menace of terrorism, and menace of arms dealing. Today, world is facing, my lord, existential challenge from these three sources. So, my lord, and in this, our own country, my lord, we have all seen in Punjab, the whole generation of, my lord, has suffered because of drug abuse. In rural Punjab, my lord, every second or third family has one serious, my lord, drug addict. And it is a real pain to see what is happening, my lord, to young generation in this country. You have to fight them, not fight, my lord, these innocent officers and politicians here. Yes, in a PIL, your lordships have powers. If somebody questions and says that what was done by government for last 30 years was wrong, your lordships can declare so. That the rules were unconstitutional, policy was unconstitutional, government could never have given these plots. But those PIL powers are not with ED officials. Their powers are hedged by the provisions of the Act as determined by Vijay Madan Lal Chaudhary, which is grossly misunderstood across the country by ED officials and with respect, I must say, courts. With respect, I must say. As a result of that, my lord, thousands, my lord, a learned judge of the Supreme Court remarked, I think it was Justice Dhulia or Justice Buyan, who said in open court that you have launched thousands of prosecutions against people. What have you achieved? I read it in newspaper. So, my lord, courts are concerned today. Now see, second judgment, my lord, judgment of Justice Topox or whatever, Opto. Lord, please see this compilation of judgment. Very beautiful discussion by, my lord, the Honorable Supreme Court in Opto case. Lord, this is 2021, 6 Supreme Court cases, 707. Lord, in the compilation, my lords will find it at page page 396. Can you hand over the compilation, Ms. Atri?
So may I also request a soft copy if it's not in committee?
Who? This is the compilation filed by you, learned Additional Solicitor General. You want your copy? You have already.
We've not put up to circuits in it.
No, I understand that these were filed by the other side before the learned single judge. So Zoeb must be.
But it is there with you.
Filed by you, that is what that.
Yes, no, he has it. Zoeb has it.
Just turn to that. Anyway, give an extra copy, Miss Anisha. Please give an extra copy to the Additional Solicitor General. You don't lose anything in giving extra copy. Page 396.
Yes.
And your lordships may kindly turn to my lord, paragraph 10 straight away. Sorry, para 8. My apologies. Paragraph 8. My apologies. My Lord Justice Bopanna, as lordships then was speaking for a 3-judge bench. Para 8. A perusal of the above provision would indicate that prerequisite is that director or such other authorized officer, in order to exercise power under section 17, should on the basis of information in his possession have a reason to believe that such person has committed acts relating to money laundering, and there is need to seize any record or property found in such. Where is money laundering here? I don't understand, my lord. Then in every criminal case in the country, you should go and arrest people. Please do that. But do it without discrimination. Don't confine it to certain political parties. Now, para 10, my lord. The scheme of PMLA is well intended. While it seeks to achieve the object of preventing money laundering and bring to book the offenders, it is also safeguards the rights of persons who would be proceeded against under the Act by ensuring fairness in procedure. Hence, the procedure, including timeline, is provided so as to ensure that power is exercised for the purpose for which officer is vested with such power, and adjudicating authority is also kept in loop. In the instant case, proceedings contemplated under section 17 to which reference is made above has not been followed by the officer authorized, except issuing the impugned communication of 15th May to AML officer to seek freezing. No other procedure contemplated in law is followed. In fact, the impugned communication does not even refer to the belief of the authorized officer. I will show my summons under 17. Nothing is recorded. Authorized officer, even if the same was recorded separately, it only states that the officer is investigating the case and seeks for relevant documents. But in the tabular column abruptly states that the accounts have to be debit freeze, stop operation. It certainly is not a requirement that communication addressed to bank itself should contain all details. But what is necessary is an order in the file recording the belief as provided under section 17(1) of the PMLA before communication is issued, and thereafter requirement of 17(2). After freezing is made complied with, there is no other material placed before the court to indicate compliance with section 17 of PMLA, more particularly recording the belief of commission of the act of money laundering and placing it before adjudicating authority or filing application after securing freezing of account to be made. In that view, the freezing or continuation thereof is without due compliance with the legal requirement and are therefore not sustainable. Now, in our case, learned single judge asked for them that show me. He saw the file and he found that there is nothing. And as appeal memorandum says, they are only following that FIR, my lord. Now, if I were to file a bogus FIR against my lord, the highest constitutional authorities, will ED act? Nobody will be safe, my lord, in this country. Because there people have grievances. They are entitled to file. Ultimately, it's the court to decide. Now, please see para 11. Shri Raju, learned Solicitor General, made a subtle attempt to contend that power of seizure is available under 102 CRPC which has been exercised, and as such freezing of account would remain valid. We are unable to appreciate and accept such contention for more than one reason. Firstly, as noted, it has been the contention of respondent 4 that PMLA is a standalone enactment. If that be so, and when the enactment contains a provision for seizure which includes freezing, the power available therein is to be exercised and procedure contemplated therein is to be complied with. Secondly, when power is available under special enactment, question of resorting to power under general law doesn't arise. Now omit that. See last sentence of this. That apart, impugned communication dated 15/5 does not refer to power being exercised under CRPC. The action sought to be sustained should be with reference to contents of the impugned order communication, and same cannot be justified by improving the same through contention raised in objection statement or affidavit filed before the court. But it is sought to be justified by oral submissions. Mohinder Singh Gill, my lord. Just turn to, my lord, the summons which is issued to me. Page 210 or notice whatever. Yes, my lord. Please see that, my lord. 210 of the appeal paper book. It refers to file number, some my lord. Whereas I, Murali Khan, AD, am making investigation under provisions of Money Laundering Act, so and so, and whereas I consider in person attendance of Natesh, that's my lord petitioner respondent hearing, necessary to give evidence for production of record in connection with investigation or proceeding under PMLA in the above mentioned case. Now, therefore, in exercise of powers under so and so of 50, I ask you to appear. What is this, my lord? There can't be anything more lackadaisical than this. This is exactly what Lord Justice Bopanna said you can't do.
So what we are demonstrating from this page 201,
There is
210?
nothing given. No detail about the inquiry.
No
nothing.
detail.
No detail whatsoever. You can't just go on issuing because you have power to issue. And that is why learned single judge called for the file. Now please see the result of the search. Please see at 207. Even that note doesn't record anything. 207. We, the above named Panchas, having been called by Sri Arya, Assistant Director, so and so. Here we are shown authorization bearing so and so by so and Joint Director under Section 17(1), authorizing Vishal Arya, Assistant Director, to conduct search and seizure or freeze any recorded premises of so and so, Maleshwar, Bengaluru. Later introduced his assistant officer so and so. Upon reaching premises, it was found to be locked. Security guard of building was asked about current whereabouts, but Natesh informed that Natesh had gone out of station previous day. He did not know exact whereabouts. Thereafter, Natesh was contacted telephonically and Vishalarya asked him about. Natesh informed he was in Mysore and is leaving from there and will reach Bengaluru in 2 hours. At 10:50, Natesh and his wife reached the premises, unlocked the door. Thereafter, authorized officer along with his staff entered the premises. Authorized officer showed search warrant to so-and-so dated so-and-so. Before starting search proceedings, said officials of director offered their personal search to Natesh, which was politely declined. Thereafter, search proceedings were started so-and-so. The search proceedings were conducted in our presence by assistant director and staff. During such statement dated so-and-so of Natesh was recorded under oath under provisions of section 17 without any threat, coercion, inducement. Further, mobile phone of Natesh was checked. It was decided to take forensic backup of mobile phone. Therefore, forensic experts were called at around 6:20 and Ashwini arrived premises. Extraction of data in mobile was done in one hard disk, which was later on seized as mentioned in Annexure 1. Bro, do I not have goodwill? Do I not have reputation? Have I not served my country that I should suffer this kind of ignominy, this kind of treatment? You can walk into anybody's house like this because you are enforcement directorate. Bro, this has to stop. And don't allow it to continue by staying the judgment or saying that the precedent value of the judgment should not apply to other cases. Seizure is only iPhone, page 100 and 209. And my master copy of data extracted.
Done.
Now, my lord, just see, my lord, judgment in Pavan Bansal, Pankaj Bansal. My lord, just see this, my lord, this conduct of ED has been commented upon by the Honorable Supreme Court. So this is, what is the citation in this? Page 364, my lord, in that.
Yes.
Just a second. Para 20 at 382. At 382. Same thing again, repetition. This chronology of events speaks volumes and reflects rather poorly.
Mr. Dave, 1 minute. My lords, I may just point out one thing, my lord. Mr. Dave had said that the base summary was before the learned single judge and he has referred to and it was discussed. Unfortunately, the base summary report was after the judgment was rendered. The base summary report is 12. No,
it is what you said.
Mr. Dave, you said that it was before the learned judge and it was considered by the learned judge. It came after the judgment. It could never have been considered. I'm sorry. You have made a misstatement.
It might not have any relevance, but I just wanted
it has
to
a relevance as far as misstatement is concerned, my lord. He has made a wrong statement. It may not be relevant, but he has made a wrong statement. That's the relevance.
No, this judgment was prior to be summoned. That is what I asked them.
Yes.
That's all, nothing.
And
it has no
that is what I
relevance
said.
except.
No, he said.
Raju, have you had your fill? Are you happy that you have alleged the misstatement to me?
Yes, I am. I stick
Very
to
good.
it. I stick to it.
The
So
entire court heard it.
it.
Mr. Raju, let me tell you, entire court heard it. I
Yes.
said, the summary report came after the judgment.
No, you don't need to state.
Your hearing, you need to check with an ENT.
Yes.
And you are not there. Don't depend on your instructions of your instructing lawyers. Kindly, my lord, kindly clarify, my lords, that I did not say this. I did not make such a misstatement.
So
don't do that, Mr. Raju, without knowing facts.
No. You need not shout. You need not shout.
You are a very respected additional Solicitor General. I bow down to you.
No need to bow down to me. If I have committed a mistake, you can tell me. No need to bow down to me. But the fact of the matter is,
Then don't make statement like that. Please, I beg you as a friend. I beg you as a friend. I did not make such a statement. I said the summary report came after the judgment of the learned single judge. And my lords asked, I replied to that. How do you say this? I don't know. I don't know who instructs you. Irresponsible instructions you get. Para 20.
Yes.
This chronology of events speaks volumes and reflects rather poorly, if not negatively, on ED's style of functioning. Being a premier investigating agency charged with onerous responsibility of curbing, debilitating economic offense of money laundering in our country, every action of ED in the course of such search is expected to be transparent, above board, and conforming to pristine standards of fair play in action. Please see this, my lord.
Yes.
Look at the anguish expressed by the Honorable Supreme Court. It's all right, my lord, you are asked to defend it and you defend it. We have also been defending government laws. We never did it like this. The ED mentaled with far-reaching powers under the stringent act of 2002 Act is not expected to be vindictive. Please see this in its conduct. But not only ED, it appears that even counsels want to be vindictive and must be seen to be acting with utmost probity and with highest degree of dispassion and fairness. In the case on hand, the facts demonstrate that ED failed to discharge its functions and exercise its powers as per these parameters. What a certificate to abroad a premier investigating agency from the highest court of the land. In my respectful submission, facts of the present case even are worse than brought this case. Vindictiveness is writ large, and it's political vindictiveness. Somebody files an FIR in respect of some events which took place from 1968 onwards, and you take that as a basis to swoop and start investigating everybody. Give me Venkatramani. Huh?
Yes.
Yes,
just allow me at this stage, Lord, to invite your lordships. My statement of objection. Which para?
Kotal Khurhi man Lairo.
What is this? Some non-English arguments are done. We don't understand. That's all or anything further, Mr. Pradhan? So that. Mr. Dave, you are muted.
Sorry. Page 16 of my objections, Lord, I have quoted this passage on legal malice from S.R. Venkatraman's case. Was it Justice Krishna or who? No, just see. It's not. I think he's chin up already. Just show me. Para 5, Lord. We have made a mention of the plea of malice in which appellant had taken in her writ petition at page 16, Lord. Lord, we have made a mention of plea of malice which appellant had taken in a writ petition. Although she made an allegation of malice against Mr. Vyas, against whom she served for a very short period and got adverse report, there is nothing on record to show that Vyas was able to influence central government in making the order of premature retirement. It is not therefore the case of appellant that there was actual malicious intention on part of government in making alleged wrongful order of permanent retirement so as to amount malice in fact. Malice in law is, however, quite different. Viscount Halden described it as follows in Scherer versus Schill. A person who inflicts an injury upon another person in contravention of law is not allowed to say that he did so with innocent mind. He is taken to know the law and must act within the law. He may therefore be guilty of malice in law, although so far as state of mind is concerned, he acts ignorantly and in that sense innocently. Thus, malice in its legal sense means malice such as may be assumed from doing wrongful act intentionally, but without just cause or excuse or for want of reasonable or probable cause. Now, there is no reasonable probable cause. Then ultimately, my lord, in this case, they said that it would be void, such an action. Void. My lord, the last para of the judgment refers to this. I will read one sentence of, my lord, this judgment. The influence of extraneous matters, para 9, which is not quoted, will be undoubted where authority making the order has admitted their influence. It will therefore be a gross abuse of legal power to punish a person or destroy her service career in a manner not warranted by law by putting a rule which makes a useful provision for premature retirement to a purpose wholly unwarranted by it and to arrive at a contradictory result. An administrative order which is based on a reason of fact which do not exist must therefore be held to be infected with an abuse of power. Abuse of power, my lord. Para 9. Now see, learned single judge, what does he hold, my lord? Learned single judge. I'll just show some paragraphs of learned single judge and I would end, my lord. Page 49, it starts, but kindly turn to my lord, paragraphs 22 to 24. Leave it, please. I have marked every. Paragraph 22 to 24, my lord, on learned impugned judgment. I'll just finish in 5 minutes so that, my lord, if your lordships can allow me to complete.
Yes.
Lord, this is issue as to formation of, Lord, this opinion, reason to believe. Petitioner further challenges formation of reason to believe that led to search and seizure under 17 contends that such reasons are conspicuously absent. Petitioner argues no material exists to indicate the involvement, so and so. Then Lord Madan Lal Chaudhary is quoted by the learned judge. Senthil Banaji, Opto, all judgments are, Lord, ahead. Then, Lord, page 78, please see para 24.5.5 of Kejriwal. Concluding its observations in Kejriwal, Supreme Court held that reason to believe must be distinguished from mere grave suspicion. It refers to reason for formation of belief, which must have rational connection with or element bearing formation of belief. Then lordships may kindly turn, omit all this. Learned single judge has considered every judgment on the issue. Para 25.
Yes.
Now, what does the learned single judge, after looking at the entire law declared by the Honorable Supreme Court? Similarly, in the present case, the alleged predicate offence pertains to illegal allotment of sites during petitioner's tenure as Commissioner of Muda. However, there is no evidence to demonstrate that any consideration passed in relation to conveyance or relinquishment of such site was received by petitioner. Consequently, petitioner cannot be attributed any role in possessing, concealing, or using proceeds of crime to constitute offence under 3. Furthermore, mere possession of a site that was allegedly illegally allotted to accused in connection with scheduled offence does not by itself constitute an offence under prevention of money laundering. Then 27. In the light of above precedents, it can be concluded existence of reason to believe as required under prevention of so-and-so mandates presence of sufficient cause to indicate commission of offence of money laundering. Additionally, it necessitates a corresponding justification for seizure of record or proceeds of crime recovered during such. Such a requirement ensures that the said property is not dissipated. To satisfy this threshold, para 28, authorized officer must demonstrate that they arrived at an informed and objective conclusion based on credible material in their possession that proceeds of crime document relating to are likely to be located. Para 29, review of recorded reason to believe must show so and so. Then learned single judge, Lord, after recording learned ASG's argument in para 31, then Lord, learned single judge holds that, where is that para where he says file is seen by me? Para 33. Para 33. A perusal of the above furnished reasons adduced by the learned ASG in the seal cover indicates no specific allegation against petitioner except that of improper allotment of sites in favor of Parvati and that the petitioner is close to realtors. Results recorded do not in any manner whatsoever indicate involvement of petitioner in any act constituting money laundering to be in possession or be in possession of proceeds of crime in money laundering, etc. Now, this is how learned single judge takes the view. Now, my lord, 3 dates may be kindly noted. The view taken by learned single judge is, my lord, eminently just, legal and proper. My lord, 27 January 2025 judgment comes. Lord, 3 dates, lordships may kindly record.
We'll continue after.
No, just 3 dates, my lord, and I'm done with it. I have nothing more to argue. 27 January judgment comes. 25th February appeal is filed. So, Lord, there was no anxiety on the part of ED that this judgment is going to be made applicable. ED knew subsequent cases are pending. Then, Lord, no stay petition was filed along with Lord appeal, as your lordships noticed on the first hearing, when I objected to any stay being granted. There was no stay petition. On 10th March, they filed a stay petition. And now say, oh, don't treat it as a precedent. The judgment which have come, which are cited in ED's application, those 7-8 judgments, are all in between these two dates. Not only they are under the same ECIR, but they are between these dates. Now, if ED felt that it was so important for them to get the stay of the judgment, they should have moved with alacrity. They knew it was not. This is an afterthought. That's why your lordships have fixed the matter for final hearing. My lord, fix it on any day. This judgment, my lord, this appeal is liable to be dismissed. It is without merits. It has no legs to stand. So I respectfully submit that therefore kindly do not grant stay. Granting of stay would mean that, my lord, appeal stands allowed at this stage.
Yes.
And, my lord, it has been consistently held by the Honorable Supreme Court that no such stay should be granted which has a, my lord, capability of allowing the appeal at an interim stage. I have succeeded. I am entitled to the fruits of the judgment. So, my lord, I respectfully submit that even second part of the prayer, that you stay as a precedent I showed. Precedent is a right precedent. It has been correctly laid down and it must apply in the state of Karnataka.
So,
Unless your lordship set it aside after hearing. Those are my respectful submission. I therefore submit that your lord.
you have concluded?
Yes, my lord, I have concluded.
Mr. Raju, you would like to submit or we just proceed?
I have a rejoinder to submit, but the difficulty is my lord, I have a matter at 2 o'clock which is specially fixed, my lord, before the Supreme Court, my lord, court number 15. So that is my difficulty, my lord. Can I come a little at around 2:45, 3 o'clock, my lord?
That you can come.
2:45, 3.
Whenever you come, we'll just try to accommodate.
I'll try to finish off in 10.
But we want to, no stretching to tomorrow, so that.
In case there is any difficulty, I'll give written submission and ask my counterpart there to argue, my lord, those points.
No, you can come and argue for no difficulty.
Very well, my lord.
Lordships may excuse my presence post lunch, my lord. I am in difficulty. Lordships may excuse my presence.
In addition to Mr. Raju.
Yes, my lord.
Mr. Raju
We are
will be
not
there.
seeking such kind of.
Next matter is, mine is 22, my lord. It's continuing, my lord, then no need to wait.
No, nobody can wait. We are very happy.
Grateful, my lords.
I am deeply obliged, my lord. Very grateful to your lordships.
Great. Then you can come because this court will sit at 2:30, na?
2:30 it will sit. I'll finish the-
2:30 ಬೇರೆ ಲಿಸ್ಟ್ ಇದೆಯಾ? ಕೊಟ್ಟಫಿ ಸರ್?
Court officer.
ಲಕ್ಷ್ಮಣ ನಂದು ಮ್ಯೂಟ್ ಆಯ್ತು. ಹಲೋ ಸರ್, ಕೊಟ್ಟಫಿ ಸರ್? ಕೊಟ್ಟಫಿ ಸರ್? ಸರ್, ಕೊಟ್ಟಫಿ ಸರ್?
ನೋ ನಾ ಅದೇ ನಾ ಮಾತಾಡ್ತಾನೆ ಇದ್ದಾನೆ, ಅಲ್ಲಿ ಕೇಳಿಸ್ತಾ ಇದೆಯೋ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. ಈಗಲೂ ಓಪನ್ ಆಗೇ ಇದೆ. ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? ಏನಮ್ಮ? ಹಲೋ.